I thank you everyone for joining. As Hans mentioned, that's the first time we do the virtual conference. Last year we were fortunate to do this in Amsterdam and have you all gathered there. This year we hope to have a successful session as well, but this time on a virtual environment. And just as a reminder, this is produced by the GTC Network together with DPA as a facilitator. The GTC Network is a global group of leading tax litigators. And we will hold this virtual conference in 3 days, where we'll have 6 themes discussed. The first one will be how the technology changes the nature of disputes. So what Hans was alluding to. Thereafter, we go to how uncoordinated tax policies put multiple claims on the same profit. So how there's a war on tax policy between organizations and governments where the same profit is taxed more than once. We have onshoring of intangibles. We will also have alternative dispute resolutions and how they can replace or they will replace the common ways of dispute resolution. After that, we will talk about how to balance transparency and social responsibility. And in the last sessions, we will talk about the impact of EU state aid cases on disputes. So the whole conference is surrounding the GTC network, so global tax controversy, and we hope you enjoy it.
Welcome. We will continue on the how to deal with extreme tax authorities' positions, and the first slide we would like to share with you is a slide we just have been addressing in one of the breakout rooms, but just for reference purposes. This is a visualization of taxpayers' rights, and you can look at it as a game of Monopoly. You start in the beginning with the right to be informed, and you end up at the finish with the perception that your taxpayers' rights will be honored. That's as we learned from the previous breakout that was in room 2, is kind of a challenge, and especially when we see the cycle of how tax authorities deal with data at source rather than 12 years down the road. So if you take data on a transaction and you need to resolve it through an EU arbitration convention, it could take up to 12 years to get things resolved. And if like in Brazil, the tax authorities look over your shoulders on the debits and the credits, obviously your cycle might even migrate to an 18 months cycle, meaning a very short cycle. This visualization of taxpayers' rights and threats was just a series of illustrations where if I take one or two just to give you some idea, the right to privacy we discussed before. Well, if you have a CBCR with a lot of data which is being used by the tax authorities to collect, not necessarily to levy the right amount of taxes. If we would go beyond that and say, okay, maybe a public version of the country by country reporting is the next step in the universe of international tax, you can imagine that undermines the right to privacy of corporates, and in addition, business secrets corporates are dealing with as well. If I take another example from this, where the right of access and rectification or even erase and blockage of your information, we had 2 examples. Luis brought one example to the table where one government in Latin, before they exchange information, they allow the taxpayers a hearing. So the hearing allows the taxpayers to formulate their arguments why or not that information should be shared with through an exchange of information clause with the other authorities. Another case which we know is a recent Supreme Court case in Holland, where the algorithm on which you put the square meters in and everything you knew about the real estate, delivering a real estate value on which real estate tax was being levied, was brought to the Supreme Court, and the Supreme Court said, well, on that algorithm, tax authorities need to disclose which data they used. They need to disclose what calculations the algorithm actually embraced, and also the thing which not necessarily needs to be disclosed is what is the good or bad profile of the taxpayer thus far, which is then still being kept as a secret position the algorithm was dealing with. I'm opening the floor to you, Catalina, to also address a few of the points you have been seeing on this road of taxpayers' right from start to finish, which do create some base erosion on taxpayers' rights.
Well, I think that we have.
Catalina, you're on mute. Yes.
Sorry, Steef. Yeah. So obviously, in developing and less developed countries, we have to deal with it in probably in extreme cases. So, for example, we don't have quality services from the tax authorities. Sometimes we don't have those rights to be informed. Sometimes we have these secret audits from the tax authorities that rule out taxpayer rights. The right to pay no more than the correct amount of tax has been rejected even for many tribunals in Latin America, for example. So even though you claim that you have that right, they just ignore it. The right of rectification, erasure, and blockage sometimes is also blocked by several administrative paths that you have to take in order to be erased from these lists when the tax authorities have put you in a wrong manner. Legal remedies in general, we have access to those legal remedies, but also we have to accept that we don't have those remedies resolved in time, and we don't have access in general in these countries to arbitration, which is a big problem, and that is something that we fear a lot now that we are discussing pillars 1 and pillars 2, pillar 1 and pillar 2 in this digital economy discussion that we are having now. So what's going to happen with us, because probably we'll be in the worst scenario. So I think that those in general, Steef. So please go on.
Okay, thank you very much, Catalina. Now it's time, because some of you already were looking at this picture in the previous workshop. Time to go on and say, okay, what's the typical dimensions we're looking at, and I would like to also open the floor to Hans, Raymund, and Maarten to jump in. But what we've done is just to collect a few illustrations, but try to categorize it. What is invading or eroding taxpayers' rights? There is the criminal dimension, as we already alluded on a couple of times, where tax authorities are collecting information, but at the same time, almost on a parallel road, like in Germany, start criminal charges against the general director of a refinery plant, which was an audit I was involved in. Obviously, that makes the general manager a lot less certain on what he can disclose at what stage, because the procedure with the corporate was still very administrative. Another example, I think, is Italy, where and a lot of compromises with the Italian fisc. They want you to sign up that whatever you agree on in profit adjustment cannot be brought through a MAP procedure into an EU arbitration convention process. So basically, they block the way into resolving that double taxation in a very unilateral way. They make it conditional on the compromise they offer you on a piece of paper. So that this is some criminal dimension. Another dimension is, as already notified by a few of you, the wrong incentives. Here are a couple of them. Catalina, you mentioned Colombia. There's a correlation between the level of adjustments you bring to the table in your bonus if you're working with the tax authorities. Italy, the fairly low remuneration for representation in the system is an issue. Cambodia, Ron was telling me that if you share your information with the tax authorities, there is a serious leakage to your competition, simply because of the low pay the tax authorities are faced with. Wrong incentives. I don't know whether the word wrong is appropriate, but as we know from the Caterpillar case we run a year ago in our face-to-face Harvard cases, there was a whistleblower system in place in the US in general, but also for taxes, where anyone who acts as a whistleblower gets 10% of the extra levied taxes, which obviously creates different incentives even for people within the company. I think a lot of whistleblower type of responses are coming from in-house troops, if you do turf a lot of cases. Another category is blacklists. Greek, for example, published a blacklist of corporates and citizens with tax debts in excess of a certain amount. EU uses the blacklists quite frequently. These are, again, illustrations of trying to categorize the illustrations of all these factors. Transparency is the coin on one side, and some call it leakage on the other side of the same coin. So we talked about the country-by-country reporting. We also talked about the DAC 6, which puts multinationals as well as their advisors in mandatory disclosure processes. FATCA, very known to a lot of people. Mexico and Greece, where tax authorities use a signature by the external auditor to make sure the whole transfer pricing is in place and is being disclosed. And then more recently, we see a lot of movement on trying to not only capture the leakages, but trying to see where ultimately the money will end up with. So the whole UBO, ultimate beneficiary register, registration is going to be a major issue in terms of transparency and leakage. With that, I want to, because there's some more categories, but I want to open the floor to Hans and Maarten and Raymund for some comments from their side.
Sorry, Steef, I want to add something. So,
go ahead,
in the criminal dimension, I also want to to say that Colombia and other Latin American countries impose large penalties for not disclosing information, even if the taxpayer invokes the right not to incriminate himself. And those penalties are really, really large. So from the blacklist's perspective, there's the proposal of Mexico, and I think that they are implementing it now, of blocking the applications, blocking the apps, if the international companies that are providing services to Mexican residents do not get registered before the tax authorities. So in practice, if, for example, Netflix doesn't register and pay, the digital services VAT, the applications can be completely blocked, which is certainly like dictatorial, I would say so. And transparency, many Latin American countries are also discussing mandatory disclosure rules for advisors, which for us is terrible, because if we don't have enough guarantees, that would be very difficult to deal with. That's it.
Thanks, Catalina.
Shall I add something, Steef? Because
yes, please.
I like the column wrong incentives a lot. And I am working currently on a court case in Italy where I support the Italian law team, lawyers from a US multinational in a withholding tax case. And I did that previously already a few times. And apparently it's quite difficult to get a case being won before a lower court in Italy. Together with the lawyers, we stepped into some detail, and then we came to the conclusion that based on a law from, I believe, the beginning of the 90s, Italian courts, by the way, are not being paid from Italian resource, but they are paid from the Ministry of Finance. The judges are people from Ministry of Finance, and they get per case, I repeat myself, per case approximately 30 euros. So whenever you have a case in Italy and the tax administration steps in and produces, like in my last case, in the first round, approximately 80 pages, then you have to ask yourself the question, is the judge going to read that? Then we still have to respond, so more pages will follow up. So is the judge going to read? So the judges, they get exactly the same for a complicated international tax case than for a simple VAT case with a butcher in an Italian city or whatever. That is a wrong incentive in a way, because I cannot place it in a different category, because it's impossible to get your rights in a sufficient way. And here in this specific situation, we are working on an alternative approach to see whether we can do something with this position. But this is just an example on how systems can work, and that you are going to be surprised by some states having such systems in place that legal protection of taxpayer rights are just not available at all. That's my first comment.
Thanks, Hans. Maarten, Raymund?
Yeah, if I may have some comments, whilst I agree and I recognize various of these positions taken by certain tax administrations, also in the countries where my business operates, practically speaking, it's a lot of focus on direct taxation and actually tax authorities claiming money from you. However, the reality oftentimes in the business is that you're also sitting on claims. So you either you need to claim back money from the authorities, whether it's an income tax, whether it's VAT, or whether it's a customs and excise duty claim. In those situations, tax authorities, they can be equally aggressive and even not more aggressive, which makes you actually, as a taxpayer, in a very difficult position, because now you are the one who are wanting to money from them. So there's two ways from a business to look at it. So yeah, they want money from us. Okay, so you need to know your taxpayers' rights. Fair enough. And that really depends, I guess, on the rule of law in a country. We've all seen the examples, and we probably all know a number of cases. Each country, you can basically prepare a heat map of how where that country actually lies on the risk of applying the rule of law or not. But when it comes to non-income tax matters and tax claims, all countries are almost all the same. It's extremely difficult, even though you got all the documentation potentially or substantially for a VAT claim. There needs to be one administrative error in a VAT claim or VAT audit. They don't want to refund you the money, and they can drag their heels and extend audits till hell freezes over. And there's not only one country, it's basically a significant number of countries. So the struggle is, okay, so how do you actually enforce your rights? Very, very difficult. And practically speaking, you need to rely on very, very good contacts you have in the country involved. And contacts meaning whether that be on a ministerial level, whether that be on essentially administrative level, especially large multinational operating entities, they have a zero tolerance for bribery and corruption, which makes it, and I'm not only talking about countries in Africa, it's still happening in a wide number of jurisdictions where you are able to resolve a dispute, but essentially as an international organization, you cannot do it.
Yeah.
Which those I think some practical perspectives that it also goes beyond just the authorities having access to the information. It is oftentimes very, very simple and you cannot resolve it. So those, I would say, there are some of the observations I have on positions, which at least in the eyes of the management of a business, they're unfair.
Maarten, a question: Do you typically, if you have a receivable on VAT and you have a payable on corporate income tax, are you trying to play the game of bundling certain positions and taking
good question.
the better position, because typically you deal with different groups within the tax authorities who have their own?
Yeah, good question. So, some countries allow it, others simply by law do not allow it. So the starting point is, does the law allow it? Second of all, even if the law does not allow it, then create the law to allow it. We've had instances where we actually had to go to the ministry to actually create the law allowing that. The fundamental problem oftentimes with these setups, if you will, it is, and it's got nothing to do with technicality, it's the fact that when it comes to VAT, and especially customs and excise is dealt with by a different authority. It's by the customs authorities rather than the income tax administration. They have their own P&Ls. An income tax inspector, they have its P&L, so they're not willing to give away money to the other department. It's as simple as that. So it's, I would say there are certain countries, especially in Europe, I'm aware of a number of countries where this is possible. But then you need to essentially have a meaningful discussion with both the income tax inspector as well as the VAT inspector. And they need to be able to also figure it out together and agree to that. It's not easy, but it's doable. Most countries, it's very, very difficult. Unless you go through political lobbying and actually get a specific degree for the set-off. Or sometimes, and I guess it goes a little bit further than that. If you're really ingrained in a country, and this is like as a practical dispute resolution style, you cannot resolve your dispute, but ultimately, if you cannot recover money, you get something else. Especially in the situation where my business operates, we sometimes have we have regulated markets where products are being regulated, prices being regulated by the government. So you just get essentially compensation through different means.
Maarten, a question. Do you see quality as an issue in the day-to-day negotiations with tax authorities?
Absolutely.
Lack of quality, let's maybe rephrase it a little bit.
Absolutely, and that absolutely, and it's twofold. And it's sometimes the lack of quality, but also what's the intent of a tax inspector. All these cases said, well, they sometimes, especially when it comes to transfer pricing, you can have all the quality that you want. You can have all the papers in the backup and the documents that you want. They simply need to collect a certain amount of money. So the technical discussion is out of the table. But more dangerously, I guess, for some corporations, especially if you have cross-border operations and are very, very centrally led, the organization itself simply makes mistakes. Where people work, mistakes are being made. So as an organization, you make mistakes. Whether you have essentially a document which is incorrect in a folder, or a VAT rate which is incorrectly posted. It's very, very simple stuff. So quality is absolutely an issue, but it starts with the basics. Get your basic quality right. Once you've achieved that, you're already very well advanced, because also tax authorities, they're not stupid. They go for the low-hanging fruit, and rightfully they do so.
Yeah, but is your position about experience, does it also go for let us say the EU member states? Because I experiencing an increased level of knowledge, however, still it's the same outcome. So they last week I worked on a case in Bulgaria. I didn't expect anything. Steef actually put Bulgaria on this list of the data mining countries, but apparently the work they created was from a content point of view. They left out exactly the things which were important, but probably on purpose. But that's another thing. And further on, they did connect the dots very, very well. I was surprised about the level. Happily, we could of course challenge it, but yeah, it isn't that bad as I believed it was.
No, I agree with you. And whether that be EU countries, it's also like UK. We've got a significant number of dealings with the UK. They're very, very knowledgeable, but they also understand complexities of business operations. As long as you're able to explain a certain business outcome, they are willing to listen and accept that argument. Whereas some other countries, Greece, VAT claims in Greece, I'm not sure whether there's a single taxpayer who got a VAT claim back. I also have experience in a prior life trying to get VAT or even corporate tax claims back in Cyprus. It's simply, the law says, yes, you are allowed for the claim. It just doesn't happen.
Yeah. Hans, on your point of quality, you mentioned a minute ago that you are doing this audit in Italy with some colleagues there. I'm just a little bit wondering, when I look at quality, I have a case momentarily where I really, really doubt the quality of the tax authorities. As simple as a benchmark, rejecting a European benchmark, which on the OECD is definitely something you can and should be able to do. And I understand that Italy has signed up to the OECD. They still completely didn't accept it. So now you have a question around using that benchmark and maybe go to court. Now I'm a little bit scared again by the lower court argument that you just brought forward, which just drags the time out to get your right, if you will. In the discussion, they come up with a benchmark, which is only Italian companies, and the Italian companies, when you look at them, actually quality-wise, they are extremely low, if not to the point of absolutely not acceptable. But still, you are in this quote-unquote highway robbery mode, where either you accept and settle to the best you can, or you go to court with all the risk. How do you judge this from a quality and taxpayers' rights on having a fair treatment and have knowledgeable people in front of you?
Exactly. This case I had with Frank Herveld 2 years ago, where the Dutch tax administration for a Belgian multinational rejected the benchmark. And it was understandable because it was about coffee cups, and there were lady dresses, and there were amplifiers, televisions, we're all part of the group of companies which were used to make up that benchmark. So in the first instance, when the tax authorities rejected that benchmark, I could understand this. However, they came up with their own benchmark. They said, this is, we believe, much better benchmark, the JITSIC benchmark. And I asked them, okay, please explain to me. So not at the first moment. So we received that benchmark from the tax authorities. We dived into that benchmark. And then we noticed that also that common procurement benchmark of JITSIC, we discussed, I believe, in the past once, Raymund, contains so many companies which were also not comparable at all to the product that was being made. So we asked the tax authorities in the next meeting, well, we have looked into your benchmark as the alternative, and actually we see comparable problems as you have with ours. They made one remark. Sorry, Hans, they said, we will drop the argument that we will reject this benchmark, and it was over. Give it a try. The Italian tax authorities know what they're doing. They are clever. They actually, in one of the cases, used the Dutch substance requirements to prove that an intermediary company in the Netherlands didn't have enough substance. So they are creative. They are well aware of the things happening. So, but that's what I would do. If you have to go to the court for a benchmark, we have a very sophisticated court in the Netherlands. Transfer pricing cases, well, they're coming up now, but 2 or 3, 4 perhaps in the history. So I wouldn't go to Italy to the court with a benchmark case.
No, we didn't do that either, Hans. I think, but the question is more fundamental in nature. I think when you look at all the requirements that are put into the laws of any country, if you look into the requirements that OECD is putting on companies, or what the EU is putting on companies with CBCR, etc., if you put that all together, they are expecting top quality of any company in terms of reports that they file, in terms of data that they share. The reverse situation, I find it very, how shall I say that, a bit more diplomatic. I think that's worrying, because where is here the balancing game? I think there was, way back, the tax authorities felt they didn't get all the information, they didn't have all the oversight. You just mentioned your JITSIC multiple country audit. I think that's fair enough. I think your 0-1, you were able, as we discussed that already some time ago, you were able to create a 2-1 win on that one. So it is still possible, but I think you can only do it on quality. But I think one aspect is very critical. You need to have proper courts that can protect you, that if you do it in the right way with the right documentation, you get your right. And in the way that the Italian tax authorities, I agree with you, by the way, they're very smart. They're not stupid at all.
No,
they
not
play their game, and I call the game highway robbery. But how do we sort of get there? How do we now start getting the balance back?
If it's transfer pricing, you can still use the arbitration convention. You can use, if it's a new case, the new dispute resolution directive.
No, I take the point, but that's fundamentally right.
Yeah.
The only thing, and this comes back to what Maarten is saying, and Maarten, chime in if you want to, because it's very practical. It's on the ground dealing with people, and I think any company will think twice whether they want to be dragged along for the next 8 years on a court case cycle. That's where you don't know what the ultimate outcome is, where you may have a feel. Your advisors will then have to tell you what their judgment is. How do you lock in on that? So it's very good to go to court, but I think it's more fundamental at the basics. But I don't know, Maarten, whether you share the same experience.
I do, and in fact, what I see, and I don't necessarily see that in Western Europe, for the simple reason my organization doesn't have a lot of operations within Western Europe, but I actually see tax administration, I would say, being aggressive on transfer pricing, whether that be not allowing certain comparables, which we believe are fair, or they simply do not allow loss-making companies to be part of the mix. But what I see increasingly is tax administrations actually enforcing an adjustment with only one reason, is to take it to the court, because the moment you, as a taxpayer, need to go to court in order to defend your rights, you need to pay a guarantee or a certain percentage of the adjustment. So basically, they have in mind, we want to collect $3 million. I just pick a number. So instead of going for an adjustment leading to $3 million, they go for the 10 million adjustment. They don't care. They know they're going to lose, but they're going to collect essentially 30% of that amount when you take them to court. So I would say, like you said, the Italians are not stupid. Tax administration are definitely not stupid. They play by those rules, and I increasingly see more and more tax administration basically playing by these rules. And those are the rules of engagement. And I'm very fearful that, given that many tax administrations across the world, they need to collect way more taxes in order to cover all the COVID incentives they've given and bailouts they're paying our taxpayers. This is going to be an increasing phenomenon in many more jurisdictions, and not only in the funky countries, basically using it to collect tax. And they also know it's going to be dragged in the courts. They can also drag it through the courts for like 3 or 4 or 5 different years. And they know that, but we know that.
Just to add something to what Maarten said, there's a ruling of the Constitutional Court of Colombia which declared against the Constitution that issue of asking the taxpayers money in order to get to the tribunals or warranties. So you have direct access, and it was because of a constitutional judgment.
Okay.
You're lucky enough, one country which actually blocks essentially. So you need to go to the Constitutional Court to actually
No, but it was a general judgment, so it is applied. It is applied to all the cases after that, because that was a general, what we call a general scrutiny of the law. So the effect is general. So we don't have to go to the Constitutional Court anymore. So that's the judgment. That was the judgment, and so we can go to jurisdiction without paying any money. Thanks to the Constitutional Court.
You're still very lucky. You can go to the Constitutional Court. We are the only country plus one Caribbean island which is too small
I know.
an office where you cannot test the law to the Constitution.
Hold on, Hans. You need to know where Catalina is coming from. She is referring to a country who eagerly wants to become an OECD member.
I know that.
In order to become an OECD member state, you need to do this. There's no other way.
Thanks, guys. This is a very entertaining conversation about constitutional law. We have 5 minutes left, so we have another example of categories. An interesting one is, let's not call it CIT. I think everyone's seen the digital service tax with all the consequences, but also the alternative minimum tax in the US, or as I think Luis and Catalina brought to the table, extra contributions paid on royalties which don't have a corporate income tax status. Another category is the treaty override, which in the breakout sessions I would like to promote those. Gunnar will talk about Germany, where Germany has the approach now that withholding tax is applicable whenever a company sells from outside Germany into Germany to German citizens and has a right registered in Germany on say a patent or a piece of technology, yet the payment of the royalty happens outside Germany. So the withholding tax is then being applied on that. So Gunnar is going to address that in the breakout. Mukesh and a whole team will be talking about the Vodafone case. As we all know, this expands the whole spectrum of tools beyond just a tax treaty. You go back to the arbitrage clause in an investment treaty. We already addressed the Italian compromise with blocking your way into the EU Arbitration Convention. A cultural dimension, which someone mentioned, I think it was you, Hans, if the NGOs get asked, do you want to share your individual income with your neighbor, then the answer typically is no. Although in Sweden, it's quite common, you call the tax authorities and you say, well, I'm living on number 71. Can you give me the income of my neighbor, which lives at 69? And you will actually get the number. So cultural differences on transparency do create some interesting cases. Let me see. There are 2 points. That case must be actually a couple of
Take
points.
the one from Luis. He's suggesting to use, to get taxpayers' rights to use maps, and maybe that is a point for discussion.
Yeah, considering tax authorities' positions, I read it out loud, and I think everyone sees it, that their impact on taxpayers' rights suggests the panel to face the issues of maps, which are usually dealt with no participation of taxpayer, and that's sort of the ultimate interest, of course. If you're left out of the process, you never know what's happening in that room where tax authorities are actually trying to resolve your issue.